Imagine this, you lose the lawsuit, the judge signs the order, your opponent's attorney grins like he's just won the jackpot, but here's the twist. The next day, your money is still safe. You still drive your car, sleep in your home, run your business, and they can't touch a dime. How? So stay with me, because in this video, I'm going to show you how people legally lose lawsuits and still win the financial game. And by the way, I'm Kevin, the business guy, the CEO of the Lawyers Limited law firm and asset protection planners. I've been protecting clients from lawsuits for 34 years and setting up Cook Islands trusts for almost 30 years, more than anyone else in the world. So when I tell you this works, I'm not talking theory, I'm talking courtroom tested reality. And if you care about keeping what's yours, make sure to subscribe right now, because I share the strategies that wealthy people quietly use to stay judgment proof. Let's start with a true story. Names changed, of course. We had a client, we'll call him Michael, successful business owner, decades of work. Then a business partner turned against him, lawsuit for millions. So Michael did what most people never think to do. He protected himself before the lawsuit. So he set up a Cook Islands trust with a Cook Islands LLC inside. When the lawsuit hit, the U.S. court ruled against him. The judgment came down, but here's the kicker. All of his assets were owned by that offshore LLC inside of his trust. The U.S. court had no power to reach the Cook Islands. So while his opponent celebrated the win, the victory was paper thin. Michael, he quietly moved on. And that's the difference between losing a case and losing your life savings. Now, here's what most people don't realize. The rich play a different game with different rules. So they understand something that the average people don't. In the legal system, possession isn't 9/10 of the law. Control is. You don't need to own everything. You just need to control it safely. So wealthy families and entrepreneurs set up legal layers, trusts, LLCs, and partnerships designed to separate ownership from control. So when lawsuits come, there's nothing in their name to take. They don't hide money. They protect it with legal walls stronger than a judge's order. So it's like having a financial firewall. Hackers can scream at the screen all they want, but they're never getting in. Okay, so what happens after you lose? Let's go ahead and pull back the curtain for a moment. When you lose a lawsuit, here's what really happens next. So the other side gets a judgment against you, a piece of paper that says that you owe them money. But that doesn't magically open your bank accounts. They have to collect, which means finding your assets, freezing your accounts, garnishing your wages, or forcing a sheriff's sale. And this is where most people crumble, because they never planned ahead. But with proper asset protection, that's the point where your plan starts working. And if your assets are owned by a Cook Islands LLC inside of your Cook Islands Trust, and we also do this in Belize in Central America, this is English-speaking country in Central America. We also do this in Nevis down in the Caribbean, and we put the LLC from that country inside of the trust from that country. Those three jurisdictions are the strongest. Your control disappears on paper. Okay, so here's how it works. You're the manager of your Cook Islands LLC or Belize LLC when life is calm. You can buy, sell, trade, invest, full control. Now, if a lawsuit hits or when one hits, your licensed bonded Cook Islands trustee steps in to protect you. They take over management of the LLC that's inside of the trust temporarily, and the assets are temporarily out of your hands legally. So that way, when the judge says to you to turn over the money, your honest answer is, I can't. And here's the key. Under U.S. law, that's perfectly legitimate because those assets are beyond U.S. jurisdiction. Okay, so why the Cook Islands? Why not just use a domestic trust or an LLC in your own state? The answer is simple. Domestic trusts are still under the same court system as your lawsuit. A U.S. judge can just issue an order, turn over the assets. But the Cook Islands, a small South Pacific nation, has independent courts with laws written specifically for asset protection. They're part of New Zealand, one of the most trusted countries in the world, according to Transparency International. And their statutes say, no foreign judgment shall be recognized or enforced in the Cook Islands. So that means that your U.S. court judgment is worthless there. The only way your opponent could reach your assets is to fly to the Cook Islands, hire a local attorney, good luck with that, post a $100,000 retainer bond, and start the entire case over again under Cook Islands law, where the burden of proof is on them, that is your opponent. And they'd have to prove beyond a reasonable doubt that you transferred assets to defraud a creditor, that particular creditor, and that's nearly impossible to do. So most of them don't even try. In fact, I don't ever remember a case where we set up a Cook Islands trust, and we've set up more of them than anybody, where the opponent has actually flown to the Cook Islands to file a lawsuit against them because, do the research, they're going to lose. So that's why most of them don't try. So they settle for pennies on the dollar or walk away. Okay, let's talk about the doctor who walked away smiling. I'll give you an example. This is another one. A surgeon, we'll call her Dr. Evans, had built a $5 million savings portfolio and real estate. One malpractice case, even a frivolous one, could have wiped her out. So before anything happened, she moved her investments into a Cook Islands trust with a real estate. We recorded equity stripping liens against them. So she still lived her life as normal. Same practice, same account, same control. Years later, she faced a malpractice suit. It dragged on for years, and eventually the court ruled against her. Her insurance covered some of it, but the plaintiff wanted everything else. Her attorney called her in panic. They're going after your savings, your house, everything. She smiled and said, oh, no, they're not. And she was right. The trust had already protected her assets long before the lawsuit was ever even thought of. The other side tried to collect and got nothing because while they were playing checkers, she had already finished her game of chess. Okay, let's talk about the psychology of protection. Here's the fascinating part. Once people set up real protection, they actually live freer lives. In fact, I see it all the time. They stop living in fear and they stop checking their bank accounts every time an attorney sends a letter. They focus on business growth, not business defense. Looking over your shoulder, that distracts you from your business. If you're always having to look over and defend yourself, you look ahead. You look ahead at your business, run your business like normal. Because asset protection isn't about hiding, it's about liberation. And that's the difference between walking on a tightrope with no net and walking with one. You take more confident steps when you know that you're protected. And for the record, this isn't just for the ultra rich. I've helped business owners with $500,000 and entrepreneurs with $50 million. What matters isn't how much you have, it's how much you can't afford to lose. Okay, so what about fraudulent transfers? That's a question we get sometimes. Even attorneys call us to protect themselves or protect their clients, and they have us set up the trust. We get those kind of calls all the time. And they ask us these questions. Now, someone always asks, what about fraudulent transfer laws? Doesn't moving assets before a lawsuit look suspicious, or even a little bit after a lawsuit? That's a good question. And here's the truth. If you're already in the middle of a lawsuit, your options are more limited. The U.S. courts can freeze assets and reverse transfers made to dodge existing creditors, but not if it's offshore. The Cook Islands still applies its own rules because their statute of limitations on fraudulent transfer claims is just 1 to 2 years, depending on the facts. Now, your assets are protected immediately. They have a little small window to be able to challenge it over there in the Cook Islands, but we've never seen it happen. And if they did, they would lose just from our experience studying the case law. And the burden of proof is on the creditor, not you. So if your trust has been in place long enough, or even if it's recent but well documented, they'll have to spend enormous time and money trying to undo it. And remember, to even start, they need to post that, usually what's a $100,000 retainer just to file the claim in the Cook Islands. And that alone scares off 99% of creditors. So the lesson, protect early. Don't wait for the storm. You get yourself protected immediately. Okay, here's a cliffhanger. Somebody asks, well, what if you need the money right away? So now at this point, some people ask that question. Okay, but my trustee controls the assets during the lawsuit. Well, it's better than the courts controlling and taking it all away from you. And they say, well, what if I need to pay bills or live? And that's a great question because you have access to the money anytime. It's just that your opponent doesn't. So that's a relevant question because you can't control the assets directly during litigation. But your trustee can use discretion to support you legally. So they can pay bills, they can fund investments, they can pay your mortgage, and they can even buy assets on your behalf so long as it doesn't violate court orders. They can fill up a debit card so you can go to the restaurant, go buy groceries and so on. Control automatically reverts to you once the danger passes. So you're not losing control permanently. you're loaning it for your own protection, like putting your valuables in a safe during a storm. You'll get them back when the skies are clear, but in the meantime, they're protected. Okay, here's a real case from the courtroom. So let's go ahead and take this out of the abstract and put it into reality. In the landmark case, FTC versus Affordable Media, also known as the Anderson case, the U.S. government, talk about a strong legal opponent. There's no stronger legal opponent than the U.S. government. They tried to break into a Cook Islands trust. So the defendants, an American couple, had transferred assets into their trust before the lawsuit. Now, when the court ordered them to repatriate or bring back the funds, they couldn't because the Cook Islands trustee had stepped in to protect them. That's what they're supposed to do. The U.S. court was furious. Their attorney who set up the trust had apparently not set up a Cook Islands trust before, which got the Andersons into some hot water because they made some mistakes on the trust. I think they named them as protector. In fact, I talked to the Andersons before they died. So here was the result. The government never got the money. It sent shockwaves through the legal world. Now, to be clear, we wouldn't knowingly set up asset protection from the U.S. government. But it proved in this case that the Cook Islands law really works, and even against a massive U.S. pressure. And like I say, the strongest legal body in the world is still held firm. And since then, thousands of clients have used the same structure legally and successfully. Okay, next, how do we structure it? So here's exactly how we do it. When we set up a Cook Islands trust, it's paired with a Cook Islands LLC inside of it. So you, the client, are the manager of that LLC. You keep signing authority on the accounts, full control on the investments, and daily access. The trustee, our licensed bonded trustee company law firm in the Cook Islands, sits in the background as a legal safety valve. So when you get sued, they can step in to protect you and take the management position in the LLC temporarily. So that's what makes it powerful. So you control during peace, protection activates during war. And at assetprotectionplanners.com, we've built more of these structures than anyone else, period, because we focus on doing it right. Asset Protection Planners is managed by the Lawyers Limited law firm, and I'm the CEO of that law firm, just as a reminder. So we do this right, custom tailored to each client's assets, liabilities, and timing. Okay, here's how losing becomes winning. So let's go ahead and circle back. What happens when somebody loses the lawsuit but wins the game? They didn't cheat. They didn't hide. They planned. They built their wall before the flood. They accepted that lawsuits are part of success in America. It's part of the game. And they prepared. So think of it like fire insurance. You don't buy it after your house starts to burn down. You buy it before, and you hope that you'll never need it. Because when the judgment hits and your plan is already in place, your opponent may have won in court, but they haven't really won in reality. You've won in reality. You've kept your assets, your privacy, and your peace of mind. So here's the question to ask yourself. If somebody sued you tomorrow, how much would they actually get? If the answer is too much, then now's the time to act. Not out of fear, but out of wisdom. Because at the end of the day, lawsuits aren't about fairness, they're about targets. And the people who protect themselves early, they stop being targets. So if you found this video helpful, give it a like. I'd really appreciate it. It really helps out a lot. Subscribe to the channel. And check right now, would you please see if you're subscribed? That really helps me out a lot. Encourage me to make more videos like this, and I want to see you again. So if you want to learn more about setting up your own Cook Islands Trust, Belize Trust, you can visit us at assetprotectionplanners.com, because you can't control the storms that come your way, but you can absolutely build the vault before they arrive. I'm the business guy, and thanks for watching.